What's up, everybody? Another day of Melly done. We're going to dive right in here because it's a two for today, or three for, I guess, if you count this morning. A lot of content coming out. But we are going to do the YNW Melly recap and reaction from today. And then directly after, you'll be redirected to the Scott Peterson update. The state has rested their case in chief, and there were some very interesting judgment of acquittal arguments made by the defense attorney and even the judge in that case. So stick around for that. Hit the like button on this video if you haven't yet. We moved it up just a little bit because I got to get out of here right around 5:30. And I got a big pickleball match tonight that I got to get to. Jason will be there as well. Dave will be there. Lucas will be there. So it's going to be a repeat of the members only video if anybody watched that. So hit that like button if you haven't already. Subscribe to our page. We're grinding away to 250K. So keep it coming, and we will keep the content coming that you all enjoy most. So let's talk about today. A lot of you said it was boring. I don't necessarily disagree, but I think there were a couple of important things coming out. First, the defense basically started off the day arguing that there was yet another violation by the state, that they are having testing done and doing work on this case and producing discovery while this trial is going on. And this is not supposed to be a trial by ambush. This is totally improper. And the judge said, we got to figure out if it's inadvertent. He specifically, the defense attorney asked the cell phone people if they ran certain testing, and they said they only ran this test and not a new test. It turns out they did run a new test weeks ago, but after the trial started, and the state intended to enter that and talk about that new test, which is totally inappropriate since, in fact, they already said no. And she said that she wants to do it because of the defense's question. And the defense is building their whole case around, you didn't do this, you didn't do that, it was a bad investigation. So to try to fix that now after the trial started is totally inappropriate. But we paused that. We got into the cell phone expert, and he started talking about the wedges and how you can use the cell phone pings to kind of see where phones go and how you can use their location services. So I just wanted to take a second with no real sound here and just give you an idea of what it looks like. Here's the cell phone. Here's the wedge. It's within this wedge that you can say this is the location of the cell phone. Sorry, I'm going to turn off the sound because it's kind of annoying. Bump this up a little. So they kind of talk about the cell phone is somewhere in this area. And he explains how as it moves and goes from one tower to the next, here are all the T-Mobile towers. And then it was clear throughout that it doesn't always go to the closest tower. It's not an exact location, but it's pretty accurate in how a cell phone moves. Here's the area of interest in that map, all the cell phone towers, Memorial Hospital. They're kind of setting the stage for where they drove that night. And then we get to something I think is very helpful to the jury, which is these little dots as we drive for the two cell phones that are involved, okay? So here are the two numbers, the red number and the blue number, and here is where they go down the streets and highways and end up. And we're going to get into more of whose cell phone is who according to the state and what car they're in and where the car drove and where it stopped and where the shootings happened and where the alleged drive-by shooting happened. So, but this I think is a very good visual for the jury because it makes them understand this is how you use cell phone location. The defense is going to have some good arguments as to why maybe this isn't very reliable, but I think as far as a demonstrative aid to the jury, this is something that is very helpful. Now, we then get even more documents and investigations as recent as 2 weeks ago that have not been turned over to the defense by the state. And at one point, the judge gets incredibly frustrated, in my opinion, with the state. And great, this video hasn't updated yet to give me the time slots that I have, but we're going to play this here and listen to the back and forth. The judge is sick of the back and forth. He's like, state, give the defense these documents, print them out, give them a copy of everything. I don't want them to argue that you haven't given them things. And that's very frustrating. It's not how this is supposed to go. The judge seems frustrated. Let's listen to just kind of a quick back and forth with he and the state here when he tells them they have to turn these documents over.
So she has in her hand some of them already. So I just want to make sure.
You're gonna make, right. Well, majority of the time. We can, but can we finish this first?
Oh, yes, I thought you were
So
finished.
you're gonna make copies of all the documents.
So she has in her hand some of them already. So I just want to make sure I don't
He literally says, you're going to make copies of all the documents. She said, well, she has some of them in her hand.
double print them.
Just double
On
print.
that. So
You know,
she-
council's suggesting she doesn't have them, so let's just print them all.
Oh, well, she does have something, just want to make sure.
The judge is like, counsel saying she doesn't have them. It's like, well, she does, judge. He's like, okay, you're missing the point. I don't care if she does or not. If she's missing one piece of paper, that's too many. So just print them all and give it to her.
For the record, on the rock.
I don't know, you know, you're saying they're sent, council suggesting she hasn't received those things. I just want her to get copies of it. I don't want your constant back and forth. Well, she has to, just get her the copies. That's it. It's easy. Just get her the copies.
He's like, had enough. He's like, so it sounds like when I talk to my kids sometimes, I'm like, I'm not asking you for a back and forth with your sister. Here's what I said. I told you to do this. Just do this. You know what you say when I tell you something? Yes, sir. That's what you say. No back and forth. No, she already has something. No, I shouldn't need to print them all. I'm telling you to print them all and give them to her. So do it. How hard is it to just print them all? So I thought that was interesting. The judge was a little frustrated there. And then after more argument about that additional cell phone testing, the judge ends up finding that there was a discovery violation and there has to be a cutoff at some point. And as a sanction, he literally said the word sanction, the second testing stuff is not coming in. Very interesting, very unusual for judges to do that, but I think it was the right call. So hours later into this cell phone expert, I want to listen to a little bit of cross because I think the female lawyer, I think this is the first witness she's handled. I know there's some stuff going around about her or whatever, which we don't need to get into. But I wish I had my timestamps more easily lined up here, but I think she does a good job of pointing out just the issues that every defense lawyer points out with these cell phone location tracking so that you guys can kind of understand what it sounds like, what it looks like, because this is not the last case we are going to hear these exact arguments on. Think this is her. I usually have my timestamps lined up, but because they haven't officially reset this video for today, it's not lining up. Let me see if I just do this. Sometimes it'll, no, it's not.
Video of them coming out of
the principle where the network is able to.
All right, here we go.
The transnational organized crime.
Okay, and that's where you learned the CAS report stuff as a collateral duty, correct?
No, I started doing CAS as collateral duty when I was a special agent working in gangs, partner state street scanning unit. And then I started doing terrorism investigations as my primary job, continued doing CAS as a collateral duty. Then I did CAS full-time in DC as a supervisor. Then I got promoted to field supervisor, which is my current job.
CAS worked with organized crime.
I kept all the cases that I had.
Has anything changed with? So you had testified earlier talking about timing events, and you said with T-Mobile they call that true data, correct?
Time in advance is the principle where the network is able to calculate the distance from a tower. T-Mobile has the brand called TrueCall that they use.
And who within T-Mobile would do the true call? Is that engineers? Who would know that information?
I don't know.
I'm going to put up your report. And looking at this band. Oh, I do. Sorry.
Thank you, Gary.
All right, so this is your report. Okay, but what does this band represent?
That is the timing advance band. So the engineering report, the TrueCall report from T-Mobile would say the distance from the tower is 0.24 miles. And so then based on the timing advance measurement, which in 4G is 78 meters, that band is 78 meters deep, so it would be plus or minus 39 from 2.4 miles on either side.
So plus or minus, so it's an estimated distance, correct?
Yes.
All right. How does T-Mobile determine? I think you testified earlier that T-Mobile determines the distance by speed times time equals distance, correct?
Yes.
All right. And how fast does that signal travel?
At the speed of light.
Right. And you testified earlier that the speed of light is a static number, correct?
Yes.
However, I tried to do the math myself because I think I'm really smart. And one of the things that I came across when I was looking at the speed of light was that it could actually be a 3 times 10 to the 8th power meters per second, or the actual number is 2.99792458 times 10 to the 8th power. So if you know, is T-Mobile using the higher number of the 3 or using the actual number for the speed of light?
I don't know.
Okay. But
So
you would
she
agree
is-
when we're dealing with
Just
the
in
meter.
case you're wondering, like this is a thing defense attorneys do sometimes. She's making it sound complicated on purpose and hopes that the jury really understands that this is inexact, and they could say it's either 2.9 or 3 to the whatever power, and it's the speed of light and all this stuff. It's like, okay, but like this is how we do it and this is how we track it. And this, if I was prosecutor, I'm going to line up the video evidence that we have and his own statements and everybody else's statements that show his phone is exactly where he says he is, until, of course, the fake drive-by shooting. That's what I would argue if I was a prosecutor, but they are kind of making this convoluted.
Meters per second, that could actually be a big distance, correct?
Yeah, so obviously the bigger the distance or the bigger the time, then the more significant the distance or the difference between those two numbers would be. Yes.
And just curious, would that estimate, because we talk a lot about sectors and I'll get further into it, is it possible that that estimate would change what sector you're paying off of?
It's possible that estimate would change the sector depending on.
Well, let me ask you this,
No.
because if you're dealing with a meter, if you're dealing with a meter, it's 3 feet, 3 inches, correct?
Yeah.
And if I'm off by 4 or 5 meters, we're talking about like 15 feet basically, correct? A little bit more than 15 feet.
Yeah, so I guess at some point there always has to be a transition from one sector to the other, because they have multiple sectors. So on the sector boundary, could that change? I guess, yeah, there's a possibility of that for sure.
Okay. Can you do this calculation yourself?
Which I did.
The calculation of the speed times time equals distance. Can you do that math yourself
Yes, I can.
by hand? And would you include timestamps when you did that calculation?
So I didn't do that calculation for this report. I used the distance that was in the engineering records that T-Mobile gave it produced. If they gave me the time, and we could use either 3.0 or 2.99, whatever the other number you said was for the speed of light, I can do math.
Again, she's saying, oh, did you do this calculation? He's basically saying no.
That's your question, right? For this report, I did not do that. I not produce these distances.
Okay. So can you tell me about any publication that would tell us about these expected accuracy of the timing advance records?
Nope.
All right. You haven't. So in your map, throughout your map, you talk about these bands and the distance from the tower. Is there any publications or any other data that you have that would explain how accurate that is?
No.
Do you know of any scientific testing outside of the legal community as to this whole cell tower stuff?
I mean, the cellular community, because this is an important part of how cell phones work on a cellular network.
Okay.
But apart from that, no.
Okay. And you show that band as a plus or minus 10 miles, correct? Is that the width of it?
No, it's 78 meters.
All right. And could you break that down? How big would that be? If you were to compare, like, would that be a football field, 2 football fields?
Now it's less than a football field, slightly less than a football field.
So slightly less, like 3/4 of a football field?
I think they are doing a good job.
And do you have any factual basis that would back that up?
Factual basis for what 78 meters is?
Yeah. No, well, the distance, the approximation of the span. Do you have anything that would back that up?
As to why it's 78 meters?
Yeah.
Because that's what based on how the technology works, based on 4G, that's what the time advance is, and that's just what it is.
So did T-Mobile tell you this in your training, or how did you figure it out?
Yeah, through my training experience, not T-Mobile specifically, but I mean, that's for regardless of whether it's T-Mobile or Verizon Sprint, 4G technology, the time advance is 78 meters.
All right. So is this an estimate that's being made by T-Mobile?
The distance?
Yeah.
The tower?
Yeah.
Yes. Yeah.
All right. So would you say that this is T-Mobile's best estimate and it's actually no more accurate than the call detail records themselves?
So I think that in my opinion, experience, generally the time in advance is accurate. Call detail records
He's like, generally this is accurate, but she's going to get into how it's not exact.
are accurate. I'm sorry, can you repeat the question?
So I was just asking, is T-Mobile's best estimate on this map correct? Is it any different or any more or less accurate than the call data records, the CDR?
Well, the call detail records will have to be more accurate because they are less precise. So without a doubt, that is the sector that the phone chose. The timing advance measurement, in my experience, is accurate, but there are factors that could make it less accurate than the call detail records. For instance, we just talked about how the difference of whatever 3 100ths in math could make a difference in the calculation of distance. Earlier, we talked about how like multi-path signal bounces off multiple surfaces on the way to the phone or on the way from the phone back to the tower. Increase the amount of time that it traveled, which would then, although I think the timing advance is accurate than call detail records.
So do you know of any publications or studies that would back up your opinion?
No.
Okay, so based on
By
the
the way, that doesn't mean they're wrong, but it makes it sound like they might be wrong to a jury.
information, you can't really tell the court precisely which locations these phones are calling in, can you?
One of the limitations of cellular analysis is that you can only say a general area where the device would be at any time.
So that's one of the points she wants to make. You cannot give anyone in this court a precise, exact location. He says yes, or he says that's correct. I cannot, because it gives kind of a range.
All right. So even with the general analysis, all of the stuff that we've gone through for about 4 or 5 hours, at the end of the day, you can never give an exact location.
True.
All right.
So that does minimize the effect of the evidence, but it doesn't throw it out, especially when a jury's trying to build a picture of what happened in this case. I think this is really helpful to have somebody like this testify, but you're going to see the defense is always going to be able to get shots in with evidence like this.
Can you tell us if the phone is on a highway?
So that depends. For one data point, no, you can't. You just general area where the phone would be. If you have multiple data points, you may be able to infer an opinion as to where you think it is. For instance, like in this case, if you see the device traveled from east to west, the towers along 595, and the time between those towers, you could infer what the speed would be, and say, okay, I think it's likely that they're on the highway because I know the area, or they're on state 34 traveling a certain speed. But from the cellular data alone, no, you can't tell if the phone was a car on the side of the road.
So can you tell if it's in the woods?
No.
How about another residence located in the area?
No.
And could you tell if somebody was walking around a car with the phone? Would you be able to tell that?
No.
Okay.
All good points, right? You can't tell based on the phone if the phone is in someone's hand, or if it's left in the car, or if somebody's walking out in the woods, or if somebody's walking from one car to the next, because we have this range and it's inexact. Those are all really good points in the stories that are trying to be connected in this case. So I do think that was a pretty good end. And she even asks, like, it could be under the seat, or it could be one person could pass it to another person and walk out of the car and leave their phone in the car, right? All those are good arguments for how Melly's team is trying to attack this case. On redirect, basically, the prosecutor nails down that this gives us a general area, not a precise location, and that's fair game. Next, we have a DNA expert. Before we get to him, I'm going to answer some questions. What do you think about the sanction given to the prosecutor? How will that be dealt with when she returns to her office? Is the jury aware of it? Will it impact the jury's decision? So not allowing them to use that evidence is technically a sanction. It doesn't mean the prosecutor's getting sanctioned, fined, thrown in jail, nothing like that. The office will not be mad. They had to try. It wasn't necessarily the prosecutor's fault. She didn't get it in, so big deal. No harm, no foul, because the evidence isn't coming in now. The jury will never know about it, and it should not affect their verdict. Skywalker, could someone please explain this to me? I assume the driver was going to testify against Melly because he's the shooter. That's who they want. Here's my question. Why not give him immunity? We still think he will, but we're waiting to see. Number one. Number two, sometimes they don't give deals until after they testify, so they don't seem like a biased witness. Sometimes they do give deals before. Tori, Peter, are you doing a Scott Peterson live after this one? I just got an alert. I'm not doing a live. I have already pre-recorded it, and it will be dropping right around 5:30. Azam, Peter, this is for Scott Peterson. Probably a dumb question. I heard objection, counsel testifying. What is the difference between leading question and counsel testifying during questioning? They sound similar to me. There are differences. Counsel saying that this is what happened is different than asking if this is what happened and saying correct after it. It's just some of the verbiage is different, but during cross, counsel is kind of allowed to testify. So there is just some nuance, but a lot of times that objection should be overruled if it's cross-examination. All right. Let me try one more time to see if they have updated this video so that I can use the right timestamps. They have not, which really is not great, but I want to get to the cross-examination of this witness. We will see if I can actually pull up the right part of it. But first, DNA expert, state calls him, more STR DNA talk, octillion times, septillion times, more likely this than that. Generally, what I think he said boiled down to Demons Melly, the defendant, his blood is not on any of the bloody things, so he didn't get shot. But his DNA was on the door handle of the back driver's seat, which is, I believe, based on opening statements and some of the evidence that's come in, that is where the state is going to be able to prove the fatal shots came from, the back driver's seat. Okay? That's generally it. And then the victims were the ones with the blood, and they were the ones that they can connect to that, and not Demons. Because a lot of people are like, how's he in the car? Doesn't get shot, doesn't get hurt, anything like that. So, the defense, though, they get up. And what is their theory? What is their plan? Bad investigation, not doing it right, trying to catch up, trying to figure it out, trying to pin it on Demons, on Melly. So one of the ways they talk about that is the timing of doing some of these tests. And let me see if we can get to the right spot because I really want to play this.
Sustain procedure.
Did you know it was approximately 3 years after he was arrested?
Additional items were submitted. These were items 40, 41.
April
Item
was
43 we want to get to.
received the blood stain on the headliner that after this trial started, correct?
I did not.
The DNA of this young man, Janelle, correct?
Speculation.
2023.
Yes, one last item, item 43.
And that was
Here we go. One last item, item 43. This is the part I want to listen to. But you heard he points out how some of this testing was not done until the trial had already started. And he wants the jury to know that. And that argument will absolutely come out during the closing statements. But let's listen to this exchange here about the door handle, the driver's side, backseat door handle.
the door handle of the rear door. Is that correct?
Correct.
And did I hear you correctly that you first ran a test and it did not come back matching or belonging to or contributor to Jamel?
That's right.
And did I also hear you correctly then we discussed something about your software with your supervisor?
Well, the technical bit, yes.
And then ran.
So at first, when you ran the test, it did not come back with Melly's DNA. When you first ran the tests.
And another test and had a 3-person contributor.
That's right.
And all of a sudden it matched or it was labeled as Jamel may have been a contributor.
That's right.
What date was it?
So you run the test, doesn't have Melly on it. You run it again. Now it says he may have been a contributor. How convenient is that? That's what the defense is going to argue in closing.
That, sir.
He's asking when he did the second test.
That was on June 1st, 2023.
Approximately 3 weeks ago.
June 1st, 2023, during this trial. Because before this trial started, just remember, there was like a month or something of jury selection.
That's right.
Who requested that?
Objection.
If you know.
What's the objection?
Speculation, outside the scope.
As far as outside the scope's overruled, if he knows he can answer.
Who submitted that item to you 3 weeks ago?
It would have been Miriam. the investigators.
Miramar Police Department?
Yes, I can look at my.
Feel free.
report. It was submitted by a Miramar investigator. Mark Moretti.
Moretti.
It was listed on the submission form.
And that was the only item that supposedly matched Jamel's DNA, correct?
I believe so. I can look back just to confirm it,
Please do.
but I do believe that is an accurate assessment.
That's the only spot they found his DNA of all the stuff they tested, or that this guy testified to, which is interesting.
Yes, there was an item with the inclusionary likelihood issue.
Could you tell these folks when that DNA was placed on, supposedly, on the door handle?
Can you tell these folks when the DNA was placed on the door handle?
No,
DNA was placed on, supposedly, on the door handle?
no.
He said, no, I cannot, which everybody knows. You never know when the DNA gets there. And that's the other point. And as Mo said, we know he got into the back seat, so I would assume his DNA would be on the handle. I agree. The point is, did he get out? That's one of the questions. But I think this scores points for the defense. That when the test doesn't come back right for the cops, what do? They go back and they retest it during this trial to make sure it points to this defendant, to get them the theory of their case, because if his DNA wasn't on the door handle, their case falls apart. And you make it a big deal as the defense, it just doesn't look good. The state holds the cards. The state has the resources. The state gets to make these determinations. The state gets to choose who they're going to charge and what they're going to charge them with. So when you make missteps like this, it can become a big deal. Witsit, that's all the replay we're going to do. So Witsit Gets It says, do you agree it appears the prosecution will need Cortland to testify pretty desperately at this point? No, I actually don't. I think the state needs to focus in. Stop doing all this other stuff and fighting about all this other stuff and focus in on, you've got the phone stuff, prove it's his phone, use those dots and where he went. Okay. And you can prove that he lied and things like that with the phone evidence. Prove he got into the back seat, which I feel like they've already started to do. Prove where the fatal bullets came from, that the drive-by did not cause the deaths. I think they can do all of that potentially without Cortland testifying. Now, I think it would be better if Cortland Henry testified, but I think it's possible to do it without him. Brenda, it's not disputed he got into the car, ergo his DNA is on the handle, doesn't make him guilty. I agree, but this testing after the fact, in my opinion, makes the state look bad. Do you guys agree? And do you think it makes the state look bad that they're doing this testing during trial, literally with new stuff coming out? I don't think it was great. And while it was not the most riveting day, they're continuing to lay foundation. We're seeing what cell phone evidence and DNA evidence looks like. We're also seeing how it's attacked. It's going to be attacked in every single case that we follow. So just get ready for that. All right. That's all I've got. So stick around for Scott Peterson. Make sure whatever's turned on needs to be turned on for you to get redirected. Hit that like button on the way out. I'm going to hit Rebecca before we leave here. I'm not going to hit Rebecca. I'm going to hit Rebecca's question. Junk science. He could have been in that vehicle at some point. Yeah, I mean, I think he was in the vehicle, but the point is, it's just, we have to remember, and that's why I love listening to the opening statements, even if I know nothing about the case. Now I know what the defense is going to prove, and that it was a shoddy investigation, it was incomplete, and it was incompetent. That's what they're going to try to do. And Gail Fisher said that DNA made me completely doubt the state. This is supposed to be the state's evidence that's supposed to be damning for the defendant. And we're all like, yeah, we know he was in the car, but wow, the state's really trying to pull something here, redoing tests that didn't come back with the results they want. That at least feels like it, right? All right, that's it. I appreciate you all. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law. is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.